Welcome back to the Law and Crime Network, and welcome to our Sirius XM listeners. It's great to be hosting here from 12 to 3. These are some great trials. We're right now in the middle of the Yesenia Sesmas trial. This is really a brutal case, right? Wichita, Kansas, a 27-year-old victim, Laura, who had a 6-week-old baby. We're going to go through some of the prosecutor and defense closings because I think that they're really, really excellent in terms of the ideas in this case. Great police work in solving it. Mother was actually killed. The baby was kidnapped and taken from Wichita, Kansas, all the way over there to Texas. Eventually, she was rescued, brought to a hospital, and then repatriated with her family back in Kansas. So listen, Law and Crime Network, it's the only 24-hour network dedicated to live trials all the time, gavel-to-gavel coverage. And I want to welcome our great guest that we have here today. She's got a very similar background to myself, which I know we're going to have some really great dialogue because there's some really good nuances in this case legally and tactically that I want to let our listeners and our viewers know about because I think that behind the scenes it's really interesting. For those of you who know me, I always like to make sure that you can go online and in the chat room ask any questions. I just ask that you do it at Bianchi ESQ so that I can look down quick. The comments have been great, the questions have been great, and it's greatly appreciated for all the support and that you give with those questions. So without further ado, Julie Rendelman is a former assistant prosecutor, and a criminal defense attorney. So we have that similar background. That was the beginning of my career as well. And Julie, I mean, just from the get-go of this case, I mean, there can be nothing as a prosecutor that you can salivate over, for lack of a better expression, than a case. I just get goosebumps when I think about it, really. I'm talking about it right now as a 6-week-old baby, Sophia, the love between a mother and her child. And look, this is not uncommon. It's not common, but it's not necessarily uncommon that you have these maniacs that are out there that actually kidnap these children and raise them as their own, as is alleged here by the state. However, unfortunately, mom was shot. And I found in my last piece before I throw it to you about what your general thoughts are about this. We're going to go through the prosecutor's opening statement. I found it to be fascinating. But when the prosecutor talked about, painted that picture, that visual that we love to do as prosecutors, about dad coming to the house and finding the mother shot and the baby not in the crib or not in the house. Well, how, sometimes we can just scoot over these things about the humanity of it all. What are your thoughts about just the general nature of this case?
Well, I mean, the last case I remember is actually where the where the defendant actually cut the baby out of the pregnant woman's body. So I hate to compare them because they're both incredibly horrific. But look, I mean, one has to wonder the saneness of the defendant in this case, simply because, there can be no kind of more vicious crime than not only the taking of the baby, but also the killing of the mother in such a violent way.
Right, yeah, I have to agree. This is like one of the worst ones you can get. But from a standpoint of a prosecutor and police, well, what an amazing job that the law enforcement did. We're actually listening to a detective who took a statement from the woman, and there's all sorts of deflection going on in that statement. My mentors, when I was a young assistant prosecutor, one in particular that I thought was just a great trial lawyer, he had that je ne sais quoi, Julie, that thing in the courtroom that you can't learn in a book. It just is what it is. And he always used to say to me, Bob, the jury loves to convict, as a prosecutor, loves to convict a defendant out of their own words, whether it be through a statement or on the witness stand. It is something that is the most powerful evidence. And here, we're listening to the detective talk about the statement and all of the deflection that was going on, and then eventually admitting more and more as that detective skillfully interviewed the defendant in this case, Ms. Sesmas, that eventually she at least admitted to the killing. Sure. And we're going to get into, so people may ask, well, why are we at trial if she had admitted to it? But I think the police did a tremendous job. What are your thoughts about everything that they did with the cell phone records? It was amazing.
I think they did an amazing job. I mean, look, what they had basically was a cell phone that, at least tied the defendant to being in the area and then moving slowly across the world, across to Dallas, to Texas, where she was eventually found. they not only interviewed her, they interviewed her husband. There was evidence, obviously, that there were pictures that she had sent of the child indicating that the child was hers. And so they did do an amazing job. I will add to kind of the thought about the opening statements, because I think as prosecutors, some prosecutors and defense attorneys for that matter, fail to realize how incredibly important an opening statement is. The opening statement is when you get the jurors on your side. And so to me, the opening statement is more important even than the summation.
Yeah, that's a common, I think, people don't realize you go to law school, they're not really teaching you how to try a case. You learn the skill set afterwards.
Right.
And I went immediately into, as an assistant prosecutor in an office where they had us back in the day trying murder cases within 6 months, if you had the background that they felt was sufficient. And they would always tell you that the opening statement is the thing that is going to set the groundwork for the trial. You need to be accurate, you need to be precise, you need to paint a great picture so that the jury immediately, primacy and recency, right, immediately understands how all the evidence that you put on piece by piece fits within the mosaic of the case. I couldn't agree with you any more there, Julie. So we're listening to the detective that took this statement. Cell phones, let's talk about that. I mean, back in the day when I was trying murder cases, we didn't have cell phones, we didn't have computers, we didn't have DNA, and I'm not that old, folks. We used to try these cases and win them without all of those things. But when I became the county prosecutor, we had numerous cases. I actually tried a murder case where cell phones were the key. It was the cell phone that broke the case because sometimes they make simple mistakes like this particular gentleman did, where he actually took the victim's cell phone with him, and we were actually able to watch a path that was pinging off towers and literally identified the cell phone in a park that was across the street from his house, where we found the murder weapon. We were able to get search warrants. We found blood evidence in the house. Boy, those cell phones are pretty amazing technology for prosecutors.
Yeah, except, the only thing about it is the cell phone, the ability to, track someone is different when it's in the city versus in like more of an urban community. And so for me, I mean, in the city, we were able to, several murder cases were solved based on the cell site towers by themselves. Now we have, even greater ability to, the experts have even greater ability to track these phones. In this case, I mean, look, at the end of the day, it didn't define the case, but it was able to basically track where she was from the beginning, middle, and end. And so we didn't have it not that many years ago. So you're not aging yourself, because quite frankly, there are many cases that we had that you didn't have any of that cell site information. You didn't have DNA. This case is quite the opposite, and it's the evidence is overwhelming.
Yeah, and sometimes as prosecutors or as lawyers and for our viewers, we kind of look at the cases, the nuts and bolts of a trial and winning it. But let's not forget, the probably most important thing of this is that the cell phone data literally led them to the house of that baby Sophia, who was inside that house with the defendant, and I believe it was her boyfriend or significant other, and they were actually able to save the child. And that probably is the more important story, and secondarily now is bringing justice to the victim in this case. So, ladies and gentlemen, we'll be with you from 12 to 3. I love having Julie here because we're going to go over those prosecution. I asked specifically for the prosecution clip of the opening statement. It's short, but we're going to go into trial tactics. And, some prosecutors try things fiery and, very aggressively. Some are more low-key. There's no right or wrong way to do it so long as you're communicating data that convinces the jury. And I found the defense opening to be really, in my estimation, bizarre. I get that they've got a really tough case here. But anyway, so we're here, Yesenia Sesmas. She's the victim's 27 years old. The other victim, baby Sophia, is 6 weeks old. Charges are first-degree murder, kidnapping, weapons offenses, aggravated interference with custody. We have the detective on the stand that's talking about what he did in order to help solve this crime. And we're on the Law and Crime Network, where we have our Sirius XM listeners and our viewers. Again, the only network dedicated to live trials all the time. I love being on this network because when you have people like Julie here and the guests and the hosts that we have on this network, you are really getting experienced trial lawyers. Not that they were great, not that we're perfect, but we're telling you the real deal about what goes on in the courtroom. I want to actually throw, though, to something that is really amazing. A great friend of mine, somebody who appeared in the media for many, many years, Lise Wheel, who is a host here on Tuesdays from 3 to 5. She's actually yet produced another amazing book. It's called Hunting Charles Manson. And if you go online, you can actually see the promo of this. You know, Julie, I was looking at the promo and I found this to be odd. I was just a kid when Charles Manson was there, but there was something in the promo on the lawandcrime.com network that really struck me about how moms and dads started locking their doors and walking their kids, because it was one of the first cases that showed the brutality and mania when we used to always be able to just run around without any parental supervision. And Lise does a great job at explaining how the Charles Manson case changed America. So we're going to cut to a commercial break, and when we come back, I'm sorry, my bad. We're going to actually look at that promo. I hope it's the same one that's on the Law and Crime Network, and it's riveting. Let's take a look at that.
We have a very special segment for you here on Law and Crime Network. Right now, we are going to take you inside the mind of Charles Manson, one of America's most infamous serial killers. And to help me do that, I have a very special guest and also a host here on the network, Lise Wheel, who is the author of a new book that's coming out, Hunting Charles Manson. First off, Lise, tell me, why did you want to write this book?
Well, you said it exactly right, Rachel, that he's one of the most infamous murderers, but he's more than that. He's really a cult figure from back in 1969. And I really wanted to write an historical thriller and talk about that era, that time, because I think it's so relevant to understand that time and that sort of cult phenomena, to understand what's going on today, and really to make sure that it never happens again.
You know, and I was reading your book last night. It's so scary to think this guy was able to manipulate these women.
That's right.
It's really unbelievable. But let's talk a little bit about this, because particularly I think there's been renewed attention towards Charles Manson because he just died a few months ago.
Right.
Walk us through a bit what your book tells the readers.
Well, it does start really with how he was able to kind of get these young women, many of them were teenagers from good homes. How was he able to sort of brainwash them and get them to actually go and commit these heinous crimes? So I wanted to follow that through, and I did that in the search for Charles Manson. In doing that, I also followed through the investigation. And Rachel,
but you're saying, I mean, they really bungled this investigation on two fronts.
They really did.
And what's kind of crazy about this case, here's this guy that was able to lure these women and get them under his spell. But he was kind of a loser. I mean, he had just been released from prison at the time. And parole officers were supposed to be keeping track of where he was. They kind of dropped the ball.
Yes, and released again and again and again from different jurisdictions, mind you, right? If the parole officers had been on their job faster and sooner, he would never have been released, or he certainly would have been checking in much more often.
But you're also saying there were some issues between the correspondence between the Sheriff's Department and LAPD. If they had shared information between the two agencies, perhaps some of these murders could have been prevented.
In the murders themselves, and in the previous murder, Gary Hinman murder, which had happened a few days earlier, which was in the area, but not quite as close as in the downtown Los Angeles area. That had happened. It had all the markings. There was, you know, blood on the walls, that kind of thing. I don't want to go into too many details, gory details, but they had literally some of the same markings. But because there was this kind of, fiefdom among the different jurisdictions, they didn't want to share information, and they bungled it in that way. And they did some pretty, silly things too, like walking on some things and tampering with evidence.
A lot of times when these law enforcement agencies get territorial over the cases, they don't want to share information. They're not thinking about the greater good here, which is stopping this guy.
Right. And the problem, Rachel, is, again, one of the reasons I wanted to write this case, I wanted to follow this case now, is that happens. That territorialism happens today as well, and we have to guard against that, because this crime could have been solved a lot faster had that not happened.
Absolutely. One last question for you before we wrap up. Let's talk specifically about Charles Manson, because he was not the one that actually plunged the knife into these victims. So that creates a whole other level. If you're the prosecutor then trying to prosecute the case, how do you convince the jurors this guy is guilty of murder if he isn't the one that actually did it? And your book takes us through that.
Yes, so this was critical at this point. Vincent Bugliosi was the prosecutor in the case, the main prosecutor. There's some juggling going on there as well, which I go into the book as well. But Bugliosi had really, new territory here, convincing jurors about conspiracy theory. Even though you're not the one with the knife, once you set those things in motion, once you tell Tex and quote unquote the girls who you've trained and you've told them what to do, once you set that plot in motion, then you are legally as liable as if you had plunged the knife yourself.
I really do encourage everyone to read this book, especially those that are true crime aficionados. It's really a step-by-step of what happened in this case, and we appreciate Lise being here to discuss some of it. Thanks so much.
Welcome back to the Law and Crime Network. Wow, that was a great interview by Rachel Stockman of Lise Wheel on her new book, on Lisa's new book, Hunting Charles Manson. Just as a quick comment, I got Julie Rendelman with me, former prosecutor and criminal defense attorney. Boy, that idea of not playing well in the sandbox and not sharing information still goes on to this day, and it is something that you really have to work on. And apparently this was a major issue in the Manson case, and it continues.
It does continue on both sides, but the prosecution is the one that bears most of the burden of turning over that material. And there's a lot of articles, even recent articles, about their inability to play nicely with regards to information that should be provided to the defense that it is either not or delayed in turning it over.
Yeah, and when you're dealing with multi-jurisdictional cases, many cases I've had have been both with state agencies, county agencies, local police departments, federal agencies. Sometimes they're just not sharing data. They're very covetous of the data, and you find out later on, if everybody had been communicating better with everybody, we would have been able to piece the case together. So I think that book's going to be amazing, and good luck, Lise, with it. I think you're actually doing a service to the law enforcement community by putting that out there. So we're right now in the Senia Sesmas case, a 34-year-old defendant out of Wichita, Kansas, who is alleged to have killed a 27-year-old Laura Abarca and abduct her, Laura's 6-week-old baby Sophia. And there was some great police work that was done here in tracking the phones down and saving and rescuing baby Sophia. But there's also a statement, and we have the detective on the stand who was discussing that statement. And Julie, I wanted to tell our viewers, or discuss with our viewers just very briefly, when you do a statement, take a statement, it is the obligation, because you have a Fifth Amendment right to remain silent, to, as a prosecutor, show the court prior to the admission of that statement that it was lawfully taken. Can you just run down preliminarily, before we got before the jury, what went on here?
So my assumption is, and of course every state does it a little bit differently, but the assumption is that the defendant made a statement, and that statement was made potentially during an interrogation. And so prior to the jury being seated, the district attorney's office and the defense attorney the district attorney present a hearing before the judge to make a determination as to whether or not the defendant was not only read the Miranda rights, but whether she knowingly and voluntarily waived the rights and therefore was willing to speak willingly. And so one of the issues that we were talking about earlier that came up was that she doesn't speak English. And so therefore they had to have an interpreter there to interpret what the law enforcement questions that were being asked in regards to the Miranda warnings. And so one of the issues, I'm sure, at the hearing, although we didn't have a chance to see it, was not only was she read the Miranda rights, not only is she required to have understood them, but did the interpreter interpret those rights correctly to the defendant?
Okay, great explanation, Julie. We are at the trial right now. The detective, there's nothing happening in court right now, although we see some activity. The detective is about to take the stand. It looks and resume questioning. We'll get that right to you as soon as they're ready to start. I agree, and just so the audience understands, essentially Miranda is that if you're in custody and you're asked questions and you are a target of an investigation, you have to be read your rights. And that is also something, in addition to whether or not they were interpreted properly, that the defense defendant fully understood their rights and that they made a full voluntary waiver of those rights and decided to speak to the police. What we have right now, Julie, is okay, here we go. Here comes the judge, right?
We have a rise. We have a rise.
We have a rise. So when the judge walks through that courtroom, everybody jumps up like a jack in the box. And he is now sitting down, and counsel is sitting down. And it looks like he's welcoming the jury back to the trial. And as soon as the testimony resumes, we are going to go right to it. So while they're just doing some, I guess, housekeeping, you actually see in a lot of these statements, though, that sometimes defendants give equivocating responses after they read their rights, like, well, should I? Or, I don't know. When I first started trying cases before they audio taped them, there was never an equivocating statement. But apparently now that we have video and audio tape, we see it happens all the time. And your detective has to be extremely skilled in making sure he doesn't violate the law with that statement.
Right, and it used to, look, I mean, when I used to practice in Brooklyn, it began that only the prosecutor's conversation with the defendant was videotaped. Well, let's go.
Okay, great point. We're going to go back to court right now and resume the question of the detective that took the statement in the Yesenia Sesmas case, and we'll be talking to you on the other end of that. Welcome back to the Law and Crime Network, your 24/7 trial network from stem to stern, gavel to gavel. I have Julie Rendelman with me, former assistant prosecutor or a district attorney, they call them out there in New York, and same thing, and criminal defense attorney. What you have just heard is the detective who took the statement of the defendant, Yesenia Sesmas, who's a 34-year-old woman who was accused out of Wichita, Kansas, of having abducted a 6-week-old baby of Laura Abarca and actually killing the 27-year-old mom. And I found the examination very interesting. Let's go through some of it because we're going to do the defense and prosecution opening statements during the lunch break. And this is what me and Julie were talking about earlier, about doing a solid opening statement so that the jury understands how the evidence is being placed. And this is a perfect witness to do that. Essentially, the defense argued in its opening statement, Julie, that, listen, there's a number of charges here, but this isn't essentially a first-degree premeditated murder. She confessed eventually to doing this, if we use that word. We actually had a debate whether you call it a confession or statement, but nevertheless, she confesses to piece of it. But the other part of it is, I did it, and here's why I did it. And you heard it very clearly. She had the gun only as a threat. This was on cross-examination by the defense attorney. There was no intention to kill her. It did not want to shoot her. The gun just went off. Didn't know it would fire. So that is a very good line of questioning on cross-examination for the defense attorney to have to lower the crime from first-degree premeditated murder to more of what they were trying to argue in opening was a reckless disregard, a substantial and unjustifiable risk. The gun accidentally went off, and that makes all the difference in the world in this case. Prosecutor wins if they get first-degree premeditation, and anything lower than that, I think the prosecutor would consider a loss. Let's go to the defense attorney's cross-examination of the cop. Did you think it was effective, Julie?
I did. I mean, look, there's not much for him to do other than to cross-examine this witness about the specific statements that the defendant made that undercut the prosecution's position that it was a premeditated murder. And how do you do that? By using the words of the defendant that are indicating that A, she didn't intend to do it, B, that the gun just went off. I happen to think at the end of the day that this is not going to hold a lot of weight for the jury because I don't think the jury is going to buy her statements to the defendant that it was an accident based on everything that surrounds this case, including the prosecutor's response, which was, did she ever explain to you, well, how was she going to get away with taking the baby? Did she expect that the victim wasn't going to call the police? Like, so all these things that undercut what the defense is trying to do on their cross-examination.
Yeah, great points. I was actually going to make that point, but I want to, when we go to the opening statements for our viewers, be very careful to listen to how the prosecutor positioned this when he was essentially saying, and I have some notes, that it's not about the evidence per se, but it's the lack of evidence, the lack of things that you would expect to see if this arrangement was in place where the victim was going to hand off her baby to the defendant.
Right.
And they're going to say stuff like, she never made an attempt to make a 911 call. She had a car seat in the back. He goes through all these things that you would expect or you don't see in the case. Now, I think the defense did as good a job as you can get in cross-examining that detective, and as a trial tactic for our folks out there, this detective was well prepared and seasoned because he didn't spar with the defense attorney. He admitted readily the things the defense attorney said, which actually probably deflates a defense attorney's cross-examination because you love it when the cop wants to spar with you. This guy was admitting what he needed to admit. Yes, she said she had the gun as a threat. Yes, she said she had no intention. She didn't want to shoot. The gun just went off, and he just said, yep, that's what she said. That's what she said. Now, I want to go, Julie, with you about the art of redirect examination. You touched upon it, and it's a hot rod for prosecutors or any lawyer for that matter. You have to be careful. It's not an opportunity to just do the whole thing all over again. The redirect has to be guided towards something that came out in cross-examination. And what I loved about this redirect was it was succinct, it was tight, and it brought up that common sense argument. Well, did she explain in all of that how it was that Laura, the victim, wouldn't have been contacting law enforcement and saying my baby was kidnapped? And I think that was a part that went right to the stake in the defense heart.
I couldn't agree more. And remember, sometimes you want it quick. You want it quick. You want to get in and out. And I think he made his points and was done. And that's exactly what you wanted to do.
Okay, you're at the Law and Crime Network. We're breaking down the Yesenia Sessions case, 34-year-old woman out of Wichita, Kansas, who is accused of abducting 6-week-old baby Sophia and killing her mother, found by the father with a shot mom and a baby that's not in the house. But we have some top crime stories for you here at the Law and Crime Network, and we're going to come back with Julie Rendelman at the other end of that and break this case down more while they're on break for lunch in this trial. Getting this groove on the FBI agent. Okay, you're at the Law and Crime Network here. It's a Dan Avens production. Trial coverage from gavel to gavel. We're in the case of Yesenia Sessions, a 34-year-old is accused of murdering a young 27-year-old woman, Laura Abarca, and stealing her 6-week-old baby, Sophia. We were just discussing with Julie Rendelman here, former prosecutor herself and criminal defense attorney, about the cross-examination and redirect examination of the detective who took this statement from the defendant. It is a perfect opportunity, folks, to go into those opening statements and now look back at exactly what the lawyers were trying to do here, because they already know what evidence is coming out, and listen to how they're trying to sell it, each side, in order to prosecutor prove first-degree premeditated murder, and the defense attorney, no, it's something less than that, even perhaps reckless. So let's go to one of the clips that really is riveting. 911 calls, finding and hunting down baby Sophia in Dallas, Texas, and the dynamic entry, as they call it, into the home. And on the other end of that, I'll come back with Julie and we'll break it down for you. Well, welcome back to the Law and Crime Network. What you were listening to there is the defendant, Yesenia Sessions, 34-year-old, who is accused of murdering Laura Abarca and abducting her 6-week-old child baby, Sophia. This is the prosecutor's opening statement. I'm here with Julie Rendelman, former prosecutor, criminal defense attorney, and we were just done listening to the testimony. We're at lunch break, Julie, so we have a great opportunity. That's why I love hosting at this hour, to talk about the nuances of trial work here. And I love that we had the Detective Ortiz, talk about this statement. We had cross-examination, redirect examination, and now we want to police. This is why the prosecutor's opening up. We're going to get to it in the next clip about specifically what the meaning of the statement is. The prosecutor will get to, but what's he doing first? His statement, I believe, was it may have been less than 20 minutes long. By the standards of a murder case, that is a really short, in my estimation. But I got to tell you, he was just ticking it off. Bing, bing, bing. And he starts off with the most emotionally impactful. We talk about primacy and recency in terms of trial work and working with jurors. And what is he starting off with? The baby pic must have come out 4 or 5 times. The gun pic, it's got sizzle to it, if you will. Inside the home where baby Sophia was actually saved and recovered by great law enforcement, and then showing the pictures where she's actually, the defendant, cutting out the parents of baby Sophia and posing that this child is her own, up to and including, Julie, the picture of her having a baby shower where she's making believe, you know, she's pregnant when she's not. She had a miscarriage. So far, the prosecutor's hitting all the sizzle in the case, and he's not using words so much as he is the demonstrative pictures that he's got. I thought he was powerful.
I thought he was powerful. Is he, you know, as eloquent as some I've heard? No, I think he's, you know, but I don't know that he needs to be for this case, because it is really pretty straightforward. I mean, the evidence that they have before them is pretty overwhelming, and you know, and certainly in terms of the issue of, as far as I'm concerned, the premeditation is pretty well laid out. And so I found it pretty riveting.
Yeah. So listen, I mean, what we have going on here, folks, is a battle, and this is why the openings are so important. Julie was talking before, I couldn't agree more. The opening is the most important part of the case because you're giving the whole framework, especially for prosecutors, so that when Detective Ortiz is testifying or the father of the child is testifying, the jury can put it into the context of what the opening statements were. So one of the things, before we go back to the next clip, because the prosecutor's going to take it from the sizzle, from all of the evidence, if you will, that was recovered in this case, because this case comes down to two things. Is it first-degree premeditated murder, or was this just a scenario where there was supposed to be a trade-off of a baby that went bad and that gun was only there and she accidentally, the defendant, shot her? But before we go to that next segment of the prosecutor, you may know, Julie, that in this case the defendant is either having and or feigning anxiety attacks. I don't opine one way or the other. Okay, I'm being told we're just going to run to the clip, and we'll get to that question from one of our viewers shortly on the other end of the clip. Welcome back to the Law and Crime Network. We are the only network dedicated to live trials all the time, and you cannot get a more riveting trial, Julie Rendelman, than the Yesenia Sesmas case. The defendant charged at 34 years old from Wichita, Kansas, for killing 27-year-old Laura Abarca and then abducting Laura's 6-week-old baby Sophia. It is a riveting case. She is charged with first-degree murder, kidnapping, weapons offenses, and aggravated interference with parental custody. We were at the point where, in testimony, we're at a lunch break now. Detective Ortiz, who took the statement, was cross-examined and then examined by the prosecutor. And we wanted to throw back to the prosecution's opening statement, because this case comes down to a simple thing. Was it a premeditated act of stealing the child and murdering the woman, or was this some accident gone awry, as the defense would suggest? And what you heard at the end, Julie, is them saying there's no evidence of the fact that she was excited to be a mother. She never called for 911 help after the gun, quote-unquote, accidentally went off, and all indications were that she just went back to Texas and was passing this baby off as her own. We were talking about the prosecutor's style. I thought he was direct, succinct, very quick, and did a very good job, and ended on a very high note for the prosecution that it's premeditated. What are your thoughts?
Yeah, I agree with you. I mean, again, I think this case is very straightforward, and so the prosecution has a lot to work with, where I think the defense has limited means to work with. And so I think the prosecution did a good job. They laid out the case for the jury. And remember, when we talk about, and you were talking about this before, about the whole idea of giving the jury a story, you know, we talk about opening being so incredibly important. It is. Jury selection is important, because by the end, when you are summing up to this jury, you want them to be on your side, and you want them to understand from beginning to end what your theory of the case was. Now, there are times when the theory will sometimes change, but for the most part, especially a case like this, you know, they have all the evidence. You know, they're going to introduce it in jury selection, opening, and then, as you see, even on their redirect, it is a re-establishing of all the things that they indicated that they would give the jury in their opening.
Right, and I think that one of the last lines the prosecutor used, I love it, because whether he did it by design or not, it was him saying, quote, a plan by any means necessary, i.e. to take baby Sophia, and that is what the prosecution needs to show that this was premeditated as opposed to the defense. We're going to get to that clip, the defense clip, because it's very interesting. Julie, you know the axiom. If you don't have the facts, argue the law. If you don't have the law, argue the facts. If you don't have both, pound the table, right? You've heard that before. So you're going to hear a very nuanced legal argument by the defense in the opening, but I have to get to Brown-Eyed Girl, who asked us, one of our viewers that put in the chat room, that Sesmis is having anxiety attacks or alleged anxiety attacks, and she is leaving the courtroom, and she wants to know, that is Brown-Eyed Girl, what happens in a scenario when, if she says, I want to be a participant in a trial, which you have a constitutional right to do under our Constitution, but yet she keeps going out for these anxiety attacks. Have you ever confronted anything like that, or what are your thoughts?
Well, we've certainly had cases where the defendant either was injured and therefore we had to take off a day or two, and so I don't think this is anything different. I know we don't take a position. I question whether or not whether she is doing this for the benefit of the jury. I'm probably a cynic, so I think that there is a part of her that's doing it. But nevertheless, as long as she is willing to be there and as long as she's healthy to be there, there should be no issue. If she decides not to be there because of a medical issue, I'm confident that the judge will not continue without her being present and instead will wait for her to be present for the jury.
Right, and to directly answer Brown-Eyed Girl's question, in many instances, this comes up, not just for medical events, but defendants who are just not acting properly in a courtroom, and eventually a judge will give some great latitude because of the constitutional principles involved, but only so far. They're not going to hold up a whole trial. Otherwise, you can imagine, Julie Rendelman, all of our defendants, when we were prosecuting them, acting out so that they couldn't go forward with the case.
Absolutely. And, look, I mean, when we think about that, we think about defendants that are either cursing, yelling, screaming, behaving badly. This is a little different because she's indicating she has a medical issue, so the judge has to tread lightly because he doesn't want an appellate issue.
Right. And, you have to also wonder, just to finalize this point, what is the jury seeing when they see this? I mean, how is this, the jury's looking at everything here. Is this being communicated to them like, oh my God, poor girl, she's innocent? Or do they look at it like this is just a get over and she's got no respect for the authority of the court? What do you think?
Well, it's a good question. And I don't know the answer to this. Does the jury know that something's wrong and they're removing her for that? Because I don't know that they do. First of all, they shouldn't be informed of it because it has absolutely no relevance to the case. So one would assume that the judge is not informing them that the reason it's being delayed is because of something that's wrong with her.
Right, yeah, we've had some instances that have actually popped out in the courtroom, like you mentioned before, outbursts and things of that nature, where even if that happens, the judge usually gives what we call a curative instruction to the jury and explains to them that that is not evidence in the case and you can only go on what the evidence is, and the Supreme Courts and appellate courts essentially uphold that. So we are at the Yesenia Sesmis trial, 34-year-old woman accused of murdering a young woman and stealing 6-week-old baby Sophia. And now we're going to go, folks, listen carefully to the defense's completely different kind of opening statement. I believe it's only 4 minutes long, but if you want a primer on what the law is in Kansas, you're going to get it in a 4-minute clip. We'll come back on the other end and speak to Julie about what her thoughts are. Welcome back to the Law and Crime Network. My name is Bob Bianchi. I'm here with Julie Rendelman. We are both former prosecutors and now defense attorneys breaking this fascinating case down at Yesenia Sesmis, 34 years old, Wichita, Kansas. Julie, accused of actually having murdered 27-year-old Laura Abarca and then stealing her 6-week-old child. We just got done listening to the defense opening statement. I'm so glad we had an opportunity with our viewers to listen to Detective Ortiz, who was the last witness before lunch break. And really, it's coming down to the two opening statements we just played on the break. The first is the prosecutor, and I'm going to sum it up in the last line he used. So I think that this is good prosecution work when you can sum up his opening in one line. It was planned by any means necessary. That gets to premeditated murder in the first degree. But if you listen to the professorial opening statement of the defense attorney, I may not be a fan of it, but he got to the point of his case. He started talking about a lot of law to the jury because, like you said, or we said before, there's not a lot of great facts.
Right.
So let's start arguing the law. And the law can be complex. And the first one he's talking about is premeditation, is the first degree. He kind of scoots past that kind of quick, and then goes into the lower forms of a murder case or a homicide case, which would be whether it was intentional, which is the desire or conscious object to actually cause it to happen, but not premeditated, not planned, even though you can premeditate a murder in a heartbeat. He's moving towards the lesser crime, and then knowing murder, where he defines, are you aware of the nature of your conduct? That's law that's pretty standard around the country. Are you aware the conduct is reasonably certain to happen? That is the death based upon your actions. But it's not premeditated. It's not planned. That's the key in this case. And then he goes all the way down. He throws the Hail Mary past the defense lawyer. It says, or it could be reckless. That is, it's not premeditated. It's not intentional. It's not knowing. And he almost kind of seems sheepish, to be honest with you, Julie.
He doesn't really want to say that loud.
He himself was kind of like choking on the words out. But what recklessness means, essentially, it's a legal definition. It means a conscious disregard to a substantial and unjustifiable risk. So, folks, now you can put into perspective how it was that Detective Ortiz was being asked questions both on direct by the prosecutor, cross by the defense, and redirect, basically getting to those legal points. What did you think of the defense opening statement here, Julie?
Look, I hear your point, and I understand that his goal is basically to try to get the jury to buy potentially that this isn't premeditated. Remember, it's the prosecutor's burden to prove it beyond a reasonable doubt, and so the one area that he maybe has some room is if just one juror buys the argument that they're eventually going to say is that her statements to the detective indicating that she didn't mean to kill her are somehow plausible. Again, I don't think they are coupled with the other evidence we have surrounding this case. But remember, it takes one juror to at least be a holdout to say maybe she's sort of telling the truth, or maybe they haven't proven premeditated beyond a reasonable doubt. I don't know that they're going to be able to do it, but at least he's trying. I have to give him something for trying.
I agree all the time. It's try that at one juror, or maybe get a compromise verdict down the road where jurors finally throw their hands up and say, look, I'm not going reckless, I'm not going premeditated. But listen, you're at the Law and Crime Network. This trial is amazing. It is the only network that's dedicated to live trials all the time like this. Love being a part of it. We're going to take a break. On the other end, we'll come back with Julie. Welcome back to the Law and Crime Network. I'm here with Julie Rendelman, and we're talking the Yesenia Sesmas case, 34-year-old woman out of Wichita, Kansas, on trial right now for having murdered a 27-year-old mother and then abducting that young mother's 6-week-old child. We have just been going through a lot of the opening statements between the prosecutor and the defense in the case, which I think very well laid out what you're now seeing with respect to the witnesses, including Detective Ortiz. So, Julie, I just want to be able to say we've got I thought one of the most powerful things the prosecutor did, in my mind, he painted a picture, and this is what you want to do, of this poor father. His name is Manuel Antonio Gonzalez, engaged to poor Laura. He has a baby, beautiful time in their life. What a cute, just this cute, loving period of time. And the prosecutor did a great job in the opening in explaining that here he is, he comes home, and there she is, shot dead, his love, his mother of his child, frantically looks for the baby, and the baby is gone. Can you only imagine? Do you think every juror put themselves in that situation and got goosebumps?
I can only, I mean, look, the facts behind this case are so troubling and so terrifying. And as you said before, this is not the first time we've heard a crime like this happening. Although I have to say that, again, what you said before, which is that the police did an amazing job of, getting this resolved pretty quickly. But it's absolutely riveting to imagine from the perspective of the father coming in and seeing this, and not only no longer having the girl he loves, but now not knowing where his baby is, which is absolutely terrifying.
Yeah, I mean, just the thought of a little baby Sophia losing her mom. being abducted by this alleged maniac, if you will,
right.
passed off as her own child. It's just a heart-wrenching story, but there's a reunification, but that'll never bring mom back to baby Sophia or her loving, engaged, person to be married, Manuel Antonio Gonzalez. Folks, I want to go to that testimony and listen to him as he explains what it was that he went through, the background of his life. One thing I love about this network is that you really get a lot of the backstory of these people's lives, not just the testimony, but people like myself and Julie who can break it down. And it's just riveting stuff. And we always used to say, Julie, as prosecutors, you're on the front row of human nature. Even though a lot of times it's sad, it certainly is interesting. This is certainly sad. And unfortunately, it's also interesting. But I'll tell you this, no matter how you add it up, it's powerful to the jury. Let's take a look. Welcome back to the Law and Crime Network, your only place where you can see dedicated live trials from gavel to gavel all the time. Dan Abrams production. Gotta love the network. Gotta love your guests like Julie Rendelman, former prosecutor and defense attorney. We were just going through some riveting testimony from this poor man, Manuel Antonio Gonzalez, who was engaged to the young 27-year-old victim who was alleged to have been killed by Yesenia Sesmas, who is 34 years old, and then that Yesenia Sesmas, had abducted her 6-week-old, or their 6-week-old baby. The husband comes home, or the engaged man comes home, finds the woman dead, finds his baby gone. Before we get to this, BB314, one of our people that comes online, said murder only. Well, listen, there's going to be some other trials. I agree with you. Got to love murder all the time. But there is going to be a really interesting case that's going to be coming up on the Law and Crime Network with North Carolina versus Wallace Bashir. Guess who he is? Guess who the defendant is? He is a district attorney who is now a defendant in a case. No, not an assistant district attorney. That's great. This is the actual head guy. This is the guy who had the position like I had. He was in charge of the entire law enforcement community in his county, and now he is sitting as a defendant in a criminal trial. And while BB314, I love murder all the time too. I'm telling you, I've been looking into this case. It is a fascinating, twisted tale, charges of felony, obtaining of property by false pretenses, aiding and abetting, conspiracy. It's what I call the wife swap case. Not in your traditional sense, perhaps, but rather that he was working with another county prosecutor to give jobs to their spouses in order to avoid the conflict of interest law for no-show jobs. I'm telling you, this guy's also representing himself in a lot of the actions here. You got to watch that trial, BB314 and the rest of the viewers. But let's go back to it, Julie Rendelman. We listened to this man talk about this horrible case, and he's coming to the scene, and he's seeing all of this carnage. And what was most important to me for the prosecutor's point of view is what the grandmother testified, what he testified. These are all data points. They never had an intention to get rid of that child. They were a loving couple and were going to raise that as a family. And again, that's another factual sword right into the heart of the defense case.
Absolutely. Although, again, you know, if she had intentions of giving her the baby, then why on earth would she need to carry a loaded gun to her home to threaten her with it? The two don't make sense. So yeah, I think I think that obviously the one thing that the prosecution has to do is to kind of debunk all the defense's positions. One being that somehow the victim wanted to turn over the baby, and we know from her own boyfriend that she didn't. We know from her own mother that she didn't. And so if she wasn't going to turn over the baby, then how on earth was she going to get the baby other than to kill her?
Right, and that gets right to where we were in the prosecutor's redirect examination of Detective Ortiz. Let's not forget the importance of Detective Ortiz's testimony here. He basically asked on redirect examination, very tight, very tailored, the prosecutor. He did it the right way. He said, well, they've known each other for years. They worked together. But she never explained how she was going to get away with this by keeping the baby when Laura did not want to give the baby up. And then he brought out the point, how was she going to stop Laura from calling the police? And then I go back to that line that he says all the time. Basically, it's like by any means necessary. Right. So I thought that was very powerful testimony from the prosecutor's redirect examination of Detective Ortiz. Thoughts?
I absolutely agree with you. I mean, you know, again, from the perspective of the defendant, it wasn't the most thought out crime, which begs to question as to her mental stability when it comes to this, because, you know, again, look, I know we're not all prosecutors and defense attorneys, but many of the things she did would have raised some eyebrows, including the fact that potentially there was a witness that actually saw her in the apartment, you know, the day that the crime happened. But yes, you know, I think that, you know, the defense is attempting through this detective to make out their case. The prosecutor's attempting through this detective to make out that case. And I think at the end of the day, I think the prosecution's, you know, going to be winning that fight, that battle.
Right. Excellent, excellent commentary. I appreciate it, Julie. So, listen, this detective is so important. Let's go back to what it was that he testified to. Do a little replay here. We're at a lunch break right now, so we had all this great opportunity in the lunch break to talk about trial tactics, opening statements, what the law is, and what each one is attempting to do in order to prove, prosecutor wants to prove first-degree premeditated murder. That is, it was planned, it was plotted, that she did exactly what she intended to do, and the defense attorney moving towards all the way down to second-degree murder, and even Julie Rendelman.